And if there is an inconsistency between center and state laws, it's generally resolved in the center. However, I mean, between center and state on items in the concurrent list, it's generally resolved in favor of center unless the president gives his assent. And then in that case, the state law will prevail. But nothing prevents Parliament from amending the state law. So Ambedkar, while in the process of drafting the Constitution, he actually invoked the U.S. Constitution. He underlined the similarities between the U.S. and the Indian Constitution by referring to it as a dual polity. And he did sort of lay out differences between the two as well. The primary difference that he laid out was that there is single citizenship in India, whereas in the US, one can be a citizen of both the state and of the country. So it's not just citizenship, it's also in the context of constitutions, whereas India has a single constitution. In the US, each state also has its own state constitution. And of course, there is the US Constitution itself. So, Professor Tillin, who will be speaking to us shortly, she's written this excellent piece on federalism, economy, and welfare in India, where she provides a very interesting perspective on the origin of the quasi-federal system that we have in India currently. So while most sort of discourse on federalism in India has been related to the partition, democratization, and liberation from local patterns of dominance, um, she looks at Indian federalism, the Indian model of quasi-federalism, as also having been shaped by sections of Indian capital, labor, and nationalist politicians to build a nationalist economy. So basically, um, she says that there was sort of a coordination of labor policies and social security to not impose extra costs on employers of certain states. So this was the sort of, the center had this sort of power to legislate on labor. So this was to sort of prevent a race to the bottom between states. Labor is currently in the concurrent list. So this sort of preempts the problems of decentralized federations such as Canada, and they shape national and regional power. So currently, the Modi government is doing something very interesting where it's encouraging state governments to deregulate and amend labor laws, overcoming obstacles to labor law reform at the national level. However, the center has centralized the design of welfare and credit schemes. So you can see that simultaneously there is this sort of this movement towards the state when it comes to labor law reforms, whereas welfare reforms seem to be pushed to the center. So this sort of weakens the center's regulatory role to prevent a race to the bottom. And this also lessens the incentives of states to cooperate with the center in improving the delivery of welfare programs. So there is this sort of odd relationship between the two. But this is also sort of in line with what the constitutional articles envision, where welfare should be the preserve of neither the state nor the center. So, moving on to the US Constitution, you have Article 1, Section 8, that talks about Congress's powers. And again, I'm not going to take you through the exact wording of the article, as I'm sure you've read them. But perhaps the most important, bit is the necessary and proper clause and the commerce clause. So it is the necessary and proper clause that is exercised by Congress to sort of give weight to the enumerated powers, to sort of come up with legislations to give force to these enumerated powers. Um, so so basically, laws enacted pursuant to the clause must be one, necessary, two, proper, and to carry into execution some other federal power. So historically, most of the controversy that's been sort of centered around this clause has been focused on the word necessary. So we've had several. The U.S. has had several cases at the Supreme Court that have tried to sort of discuss the scope of necessary powers. And so initially, the word proper wasn't given enough importance. and it was regarded as something that was merely a superfluous addition rather than having a meaning in itself. However, in 1997, there was an important Supreme Court case, Prince versus United States, that sort of spoke about the scope of proper powers. And it said that federal gun registration requirements, um, basically a federal law that required state executive officials to implement federal gun regulations, was not proper because it did not sort of respect the boundary between the federal and the state. So again, with the Obamacare case as well, which will be discussed later, the court was divided about the question of whether the law was proper. So again, we've seen some sort of more interpretations of, again, this necessary and proper clause. And the question is whether the clause, whether we can understand the clause as somehow giving some sort of agency power, allowing the agency agents to exercise powers that are incidental to the main objects, or basically giving weight to what was discussed at the Constitutional Convention, a resolution adopted at the Constitutional Convention that allowed Congress to legislate in all cases for the interests of the Union, and especially in those cases where the states were especially incompetent. So we have certain similarities between US and Indian federalism, as I'm sure you've noticed through your reading. And you see that there is a dual distribution of powers. Both have been created in a specific context, and the federal government slash union government is supreme. States do not have the power to secede from union, and the state and the federal government retain the power to declare war, mint currency, and basically in foreign relations. So there are many differences, however, between the Indian and the US model of federalism. The Indian constitution provides for a quasi-federal structure, which we discussed earlier, whereas the US constitution envisions a federal one. So there is a greater role for the union in the Indian constitution, whereas the US constitution grants slightly more autonomy to states. The restitutory powers also vest in the union government in India, whereas they vest in the states and the people in the US. So again, as we discussed earlier, there is a single Indian constitution and citizenship, whereas it's different in the US. So now we have, now that we've sort of had some sort of idea about the main similarities and differences between Indian and US federalism, and some sort of idea of the context in which they emerged, we're going to take a few minutes to think about our discussion question, which is what should the federal distributions of powers achieve? So I'll leave this on the screen just for a few minutes, and we can sort of take 2 minutes to think about it and then begin our discussion. So feel free to raise your hands if you have something to say. And again, it would be appreciated if you could turn on your video when you're answering so we can put a face to your name. Varsha, maybe you can take the slide off.
I've also put the question in the chat box, so anybody who needs to refer to it can look at that.
So I think in this context, maybe we can take a step back and sort of understand the history in which federalism, the structures of federalism evolved in the US and India, and think about what they really set out to achieve, what the framers of the Constitution really set out to achieve by coming up with these structures. And perhaps thinking of the sort of socio-political context in which these structures were evolved, what do you think were the main goals that the framers wanted to achieve through these structures? So what is to put it in a simple way, what is the point of discussing this? So we have Satyajit who wants to say something.
Yeah, so I mean, very basic, but the couple of quick thoughts that crossed my mind were first, you want some sense of decentralization in that you won't want power being primarily concentrated in the hands of one party at the center, which is maybe divorced from, let's say, people at geographical extremities or something like that. And maybe like somewhat related, you might be looking at a sense of national ownership, in that you want all people to somewhat like participate in their governance. And when you have excessive centralization, then you don't have people actively engaging with their leaders if their leaders are sitting, let's say, somewhere in Delhi, whereas you're in the south. So maybe in that sense, you're looking at some ownership in your form of governance.
Okay, so your basic point is that federalism allows for decentralization in some way and perhaps gives slightly more autonomy to people themselves. Does anyone have a response to that or perhaps disagrees with that?
And could you possibly see that as an extension to also it's moving towards state autonomy and not just autonomy to the people in the country?
If I may say something here, perhaps one way to think about the question is to think about, at least I know all of you are more familiar with the Indian context than the US, but think about what was happening at the time that the Constitution was being framed. We looked at the history of the founding of the US Constitution and the Indian Constitution in the last class. And did federalism, the structure of federalism that emerged in both the US and in India, was it in response to specific facets of that founding moment? So for example, in the US, if we saw the Articles of Federation that preceded the US Constitution, which had a very different imagination of state power versus the center, did that have an influence on how the US Constitution has shaped federalism? And if you see it in that context, then reflecting back on the Indian Constitution, what were the concerns that shaped the nature of federalism that the Indian system has? And that might also highlight some other aspects of federalism that we haven't discussed yet that that are present in the Indian context, which were shaped specifically in light of the conversations that were happening in the country, the political and the social and economic context of the country at the time of the framing of the Constitution. Perhaps Shambhavi can get started, and then Malvika and Vasha can take over. Yeah.
Hi, good afternoon. So just going a step further from Dr. Chandra's point, for sure the socio-economic conditions of the country at the time of the conception of the Constitution has a great role to play, considering that the framers wanted to hold the nation together, considering the diversity that India had, considering we were just out of oppression, of the British oppression. It was important for the framers to hold the country together. And that's why we sort of have a more centralist approach. That's why we have a quasi-federal structure in place, wherein you have state autonomy to an extent, but then when it comes to holding the country together, you need to let the residuary powers be at the helm of the parliamentarians, so that the diversity does not, so it's not how do I put it, it's not dispelled per se, but for a diverse country like India, you're sort of trying to hold it together.
Yeah, so I think the gist of what you're saying is that the structure of federalism that we have in India is more unifying. And perhaps at the time when the Constitution was drafted, there were states that were disparate in some sense, and they were incredibly diverse. So our model of federalism was probably to bring these states together in some way. Is that the sense that you have?
Yes, yes.
Okay. Priyanshu, do you have a response to that?
Yes, ma'am. So I agree with Shambhavi's point, and I just wanted to highlight one specific instance. Basically, what exactly our constitution framers wanted to achieve. I think we can get a good sense from the conversation. I mean, the competition between two different approaches at that time, right? So basically, there was one Gandhian imagination of constitution where he used to say that, okay, there should be a bottoms-up approach, and the center of the power should be at the village level, right? So the reply to that by B.R. Ambedkar and other constitution framers at that time also tells you a lot as to what was going exactly in their minds when they decided to have a constitution, which we call a quasi-federal constitution, where there is some distribution of power, but at the same time, a good amount of power has been concentrated at the central level, right? So, for example, I remember reading this excerpt by B.R. Ambedkar, where he said that, uh, I mean, India will never be able to progress if we just let village be the center of power, because there are a lot of injustices happening, and like we will never be able to like get out of that traditional bound society. So basically, I feel that the reason Indian federalism has been structured in this manner is keeping the socio-political conditions of the country at that time, and how they want to like transform the country by through the constitution at that point.
Absolutely. So you could say that in a way it had a more reformist sort of bent. It was a sort of reformist idea to bring, to sort of go beyond the village level or the micro level to think of the macro reform. So macro level reform. So I think absolutely understanding the socio-political context at that point is incredibly important. And yeah, I think that perhaps maybe we can also sort of think about the US Constitution's political context at that point. As we discussed in the previous session, we sort of spoke about how the US consisted of 13 colonies and how they were they sort of came together with the Articles of Confederation, which were a failure. And so, with the new constitution, that is the actual US constitution, what was the kind of motivation for the creation of their model of federalism? Was it related to the failures of the Articles of Confederation, the failure of the model of the Articles of Confederation of the 13 states that somehow just never seemed to come together and were not unified in any way? So, absolutely, understanding the socio political context is important. Mansi?
So, ma'am, furthering your point only, this was the only point I was going to make, that in US, 13 colonies were independent, whereas in India, the states were already aligned to make one union and to follow one union. But in USA, the colonies were very rigid in themselves and they wanted to retain their autonomy. So they began with the Articles of Confederation, which failed. But later, also, when the constitution was made, a lot of power was retained with the states, so that states still exercise some sort of autonomy. So that is probably the reason that why US federalism is so absolute, where residuary power still vests with the states and states still exercise that level of autonomy. And that does not exist in India, because Indian situation was very different from what existed in US at that point of time. So yeah, that was the point I was going to make.
Bodhisattva, would you like to add to that, or do you have something else to say?
I wanted to further Shambhavi's point, where she told about the socioeconomic context of India. There were also another concerns with regard to like reorganization of states in India with respect to languages. So languages post-independence became a huge factor in the establishment and re-establishment and reorganization of various states. And it is not until at least like 35 years that we get the present picture of like the states being organized as per the languages and all. There are still conflicts with respect to that. That is why maybe we have a more centralizing tendency in our constitution. So that is one of the factors which we have to take into consideration. This point.
So I was just wondering if perhaps you could elaborate a little bit on the language question and how that relates to federalism. Ignore my dogs.
So basically, there were concerns around like the division of states being there, and various like language movements being there in many parts of the country, such as like Andhra Pradesh, and then in even in the Punjab region. And and the founders, they had that thing in mind, that the partition was such a huge event and whatever loss happened. So in a way to mitigate all those circumstances, maybe they had created a strong unifying tendency in the constitution. So that was my point.
Yeah, absolutely. And definitely, I think the ghost of partition sort of loomed over constitution making in that sense and affected this affected the way that the country is structured. Sumit, do you have something to say?
Yes, ma'am, and this is taking forward the prompt that Dr. Chandra gave us with respect to focusing on the constitutional moment in both the context of the US and India. And when we look at bringing together disparate states which had autonomy, which had power of themselves, it was important for the central government and the Constituent Assembly and the roles they were playing to have some sort of appeasement of why would they want to join a union. And the idea of federalism that was then espoused did that role effectively to an extent. Where you look at a very Ackerman idea of like a constitutional moment, and the creation is something which gives these states, these both princely states as well as the states that were already ceding to the union, both some idea of what sort of autonomy they will have under the union, but also know that there is a provisional government above them to an extent. There is going to be cooperation that's necessity. And both in the context of the US and in India, it's interesting to note how the diversity in the colonies that were in the US as well as in India, where you look at language, where you look at culture, where you look at how diverse all of these states were, that the creation of this union of an idea of an independent nation was something which became important in a constitutional moment context as well. And I think that's where the comparative of the federalism model that we see both in India and US becomes interesting from like a constitutional moment paradigm.
Absolutely. So I think there is this sort of consensus so far in the group that the sort of structure that we have is both meant to unify and to preserve some sort of diversity. Rishank, do you want to add to that?
So I think a lot of the perspectives we're looking at right now is from the perspective of who is doing the centralizing. So we're looking at it from what the interests of the center could be. But just to apply a more like a rational choice sort of analysis to this, at the end of the day, when you're drafting a constitution which is for a large country, you're bringing in a lot of disparate interests into one block, which means you can't disregard the power that these disparate interests have. So perhaps another way of looking at the federalism question, not from looking at it from the interest of the center, but from looking at it at the interest of those who are agreeing to come to this central power themselves, and to ask ourselves, A, what is the extent of power that they have, both within their own territories and qua the centralizing power, and B, what are their interests? And I think that question gives us a lot of answers as well, because like in the Indian context, you look at how Kashmir had a lot of different powers from what a lot of the other states have. And you can't answer that only by looking at the centralizing tendency of having one national economy. You have to realize that that region had certain power over or qua the center and certain interests that had to be protected. So I think, and similarly in the US context as well, I think everyone's been hinting at this as well, which is that the US colonies had a lot more power than Indian states or provinces had. And so I think that's another different frame of looking at the question of federalism that's important, which is the power of the states themselves.
Let me jump in here just to say, I mean, that's a very interesting point that you raise, which is to think about how the different constituent units or units that were about to become constituent units, how they interacted with the center. You, of course, take a power and rational choice approach, but there might be other things at play as well. Because when, all our discussion so far assumes that the relationship of the center to each constituent unit is the same. But of course, that's not the case. Kashmir is one example. You have the 5th schedule, you have the 6th schedule, you have all of those Article 371A to GHI, all of those provinces. And not all of those sort of the special arrangements that the center and the subunit has in those special circumstances, not all of them are the same, and not all of them are dictated solely by the power of the subunit. So what else is going on? There might be, so perhaps you can explain Kashmir in terms of power. There might be other ways of thinking of Kashmir as well. What is happening in the 5th schedule areas? What is happening in the 6th schedule areas? What is happening in all of these other states that have differential arrangements with the center? Is power the only sort of explanation for why there are special arrangements between different states?
Radha, do you have an answer to that?
Through the past, we can have a systematic and focused approach towards the governance of a country. So that this is the point which I also wanted to mention, that in a federal government, we can divide the power in various different manners, so that the development of a country could take place in a more focused manner. This is what I wanted to mention.
So I think your point is more like not exactly a response to Aparna's point, I think, but sort of talking more from the efficiency perspective in that sense. I think that it's through the division of power, it's easier to sort of bring about efficiency. So yeah. Lakshmi, do you have a response to Aparna's point specifically?
Yeah, so I think other things that could be different is the kind of governance structure that existed in that particular unit. So some of them, for example, were princely states, whereas others may not have been. Some of them were, let's say, tribal colonies, things like that, right? So there was difference in terms of the kind of power structure that existed in those units itself. And therefore, in terms of how, let's say, a decision on whether or not to join the union would have been made as well. Because in some cases, there were maybe negotiations with kings or princes of those particular colonies. There was also differences in terms of what influenced sort of power structures within those, right? Like, for example, in some cases, maybe religion played a huge influence. And even in terms of the diversity of those populations, there was a lot of difference. So I think all of those also have a huge role to play as into whether or not ultimately they wanted to join the federation, and like how that decision was made even internally.
So I think your primary points are power and diversity, negotiating power and diversity. But I'm wondering if there is a certain thrust that goes beyond maybe just thinking about it in terms of power and diversity. Is there anything else that could possibly have been motivating these special arrangements between regions and the center? Like, is there anything else that sort of comes to mind apart from negotiating ability and diversity? Yavnika, do you have a response?
Hello, good afternoon. I just have a small response to this, although it has already been highlighted by ma'am in the chat. The Government of India Act has influenced the structure of this constitution, especially I'm talking about India because I think I have more knowledge in terms of the Indian constitution as compared to the US. So if we talk about the Indian context, then I think because of the pre-existing practices, and this had already been practiced for a long time, that there was a separation of powers at the state and central level, even during the British rule, even during the Government of India Act, and even sometimes before that. So that's why maybe because they thought that it's already existing and everyone's aware of the system and is used to, so we could adopt such a system. That could be a very indirect point, ma'am.
Yeah, so I think your point is that it's rooted in both a certain sense of historicity and convenience also. That since this had been the way that things were done, it sort of continued to remain in that way because it was convenient. Is that the thrust of what you're saying?
Yes, ma'am.
Okay. I think
Yeah. Sorry, can I just ask a question here? So Pranav is not here. So our resident cynic is not here. If he had been here, I am assuming he would caution us that we are thinking about constitution making either as completely based on altruistic principles, so diversity and autonomy and all these high principles, or based on just pure power play of the sort that Prashank was highlighting. But imagine if you are, think of someone like Jaipal Singh, right? Or think of someone from coming from an Adivasi from one of the 5th schedule areas or the 6th schedule areas. Is that arrangement being driven solely by high principle or absolute pragmatics, or is there a darker underside also to how that framing has happened of the arrangement between the union and these areas, the union, the state, and the 5th and 6th schedule areas? I mean, even if you're not familiar with, what happened during the drafting, you all have done constitutional law, so you know the development of case law in these areas. And does that give an indication of what else might be at play in how these arrangements were determined and how these arrangements have played out? For example, is the Indian state also acting as a colonial extractive state? And are these arrangements also being driven both by paternalistic, to put it mildly, paternalistic, with a colonizing, civilizing mission on the one hand, and the need to sort of extract resources and exploit the resources from these areas, not necessarily for the benefit of these areas themselves, on the other hand?
I think it's a very interesting perspective to think of the Indian state as the oppressor, because that's something that's typically not done so much. We tend to think of colonization as solely happening in the context of the European powers in India, but we never really stop to think of the marginalized in our country who may think of the Indian state as a colonizer and oppressor. So yeah, that's a very interesting point. I saw Radha's hand go up, but I think she put it down.
Yes, ma'am. Actually, I wanted to mention that maybe it is due to restrict the center from undue interference in these areas, and also to protect their individuality of these scheduled areas. So this is what I wanted to say.
Arzu, we'll come to you, and then maybe we can move on to our second question, our second discussion prompt. So Arzu?
So ma'am, to Dr. Parna Chandra's point, so in the reading it was mentioned that how the British Parliament wanted a federal solution for India, because they thought that by having a federal structure, they could protect their interests, they could further their interest, and they thought that if it is the best way of retaining their autocratic powers, and it is the best way of slowing down the democratization of the states, and to basically it was a conservative element on their part. So I think to some extent, yes, I agree with Dr. Parna Chandra's point that there was something of protecting their own interest and taking the resources of the states, and the economic point, I think there was present historically as well.
Okay, great. So this ties in really nicely into our next discussion prompt. Vasha, yeah. So these were the main, so these were the main sort of very broad sort of answers. So we could slot your answers into these broad categories of diversity, autonomy, and flexibility. I think we've sort of discussed them at length, so we can move on to our discussion, have India and the US achieved these goals? So we discussed the goals of the distribution of powers and what they possibly might be. So specifically with respect to India and US and the kind of what is present currently, what's happening currently in our country and in the US, do you think that the constitutions have sort of achieved these goals? So we can just take about 2 minutes to think about this. And Varsha, could you take yeah, thanks. So yeah, please do raise your hand if you would like to respond to this. And I noticed that a lot of the discussions we had in the previous session sort of tie in very well. So tie in very well to this question, since we have been discussing this in context. So if you do have anything to say, please raise your hand. So I think we discussed, so even if we go goal by goal, for instance, one of the goals that we discussed in the previous session, as in the last discussion, was diversity. Do you think that the Indian model of the Indian model of federalism, do you think that it's managed to preserve the kind of enormous diversity that we've had in this country, whether it's been able to sort of support this diversity, or whether it's had a homogenizing influence in that sense on diversity in our country? Satyajit?
So ma'am, on the three metrics we identified in the slide, right? I think the strongest impact has been in terms of autonomy, and that's where our biggest failure lies over the last few years. So I'm just thinking in terms of in India lately, there have been a lot of instances of abusive federalism at the center, right? Where you're talking about, let's say, withholding revenue by the center to the states, and maybe thinking about the abrogation of 370 and all of that. So I think about diversity, I'd say that there's been some preservation of that, because you still have regions articulating their interests strongly. But I think the biggest harm exists in terms of autonomy and how the center continues to shape that in most ways.
That's actually a very interesting point, because I think in one of the readings for today, we were discussing that in terms of, say, reorganization of states, it's the states that have sort of pushed back against the center in that sense, and sort of assume the power to sort of push through agitation for sort of separation of states or creation of new states. So it's a sort of interesting point that you make there about the sort of homogenizing influence of the union in that sense. Sumit, would you like to respond?
I just wanted to also flag that perhaps looking at just the model of federalism is a bit narrow as a starting standpoint, because especially for India, it makes more sense to look at how the constitution itself, everything that we have under the constitution, how it's essentially either inhibiting or allowing the diversity to actually flourish when it comes to the different states that we have and the sort of powers that they want to exercise. And this becomes even more interesting to note in the context of, say, recent developments, especially when you look at what sort of powers has the center really exercised when it comes to COVID, when it comes to, as Satyajit also pointed, revenue in terms of finance and economy, and especially when it comes to, say, cultural diversity, languages, we see the constitution making a lot of essentially allowing for there to be as much diversity as there can be. And that's typically what you'd want, at least from the text of the constitution. But how that pans out also depends on what party and what sort of power is there at the center, what sort of goals do they have, and what sort of role do they envisage the center to have. And in the current context, you see the center having a more in the sort of a more paternalistic role where they do want to tell states what to do, where they want to have like broad guidelines for every law that they pass, that this is what the state should abide by. And that's limiting the sort of power the states should have rather than essentially allowing for greater diversity. But I still feel that depends on what sort of government do we have at the center. And that would depend on the time, on what sort of party is there. Those considerations also come into play apart from just the text of the constitution.
Lakshmi?
So this is not something we discussed, but somebody put on the chat about how one of the goals of federalism could have been that to push for like a realization of rights, like progressive rights, through more from a central framework. And I think if you look at the example of the US, you can see that that has been done with how, and the reading that was shared for today also talks about this, about how slavery was abolished. And once it was abolished, the other states tried to use their police powers to sort of continue an equivalent of slavery, but there was the enactment of the amendment which abolished slavery and like prevented states from having laws which infringed on individual rights. So I think that's something that you can say that federalism has achieved in the US context, and I think to some extent in the Indian context as well.
I just wanted to sort of, so you were saying that it's been achieved in the Indian context as well. Do you want to sort of elaborate a little bit more on that?
I think because we have like fundamental rights in the Constitution, and the way that they've been interpreted has in some cases also been against laws which could have been enacted by the state or the center, which have infringed on those rights. So in that sense.
Rishank?
So two quick points. So the first thing is, I think when we're looking at the original goals and comparing what's happened now, especially I think in the US context, I feel like there's been such a radical change in that, even though originally, like if you look at state sovereignty, so one of the readings that you gave us talked about how the new era under both the Roberts Court and the Rehnquist Court is considered the state sovereignty era. And it's quite interesting because this phrase state sovereignty, from what I know, was used during constitution making in during these times as well, when the debates around slavery were happening. But the understanding of state sovereignty was so much different from what we now consider state sovereignty as a doctrine is. So in that sense, I would say, I think as the years have grown on, particularly in the US, even though you have states asserting greater autonomy, that degree of autonomy has fundamentally changed. And the second thing is, when we're evaluating the number of years and how things have changed, I think it's interesting to think about the impact that neoliberalism is having, because one of the ideas of neoliberalism in a globalized state on the international arena was competition between countries. So countries would be competing to have conditions that are more conducive for companies to come in. And we see that entire debate of competition between countries taking place now within countries, which is the idea in the reading you give us by Professor Tillin on Modi and his competitive federalism perspective. We see that is completely antithetical to the idea of why we wanted federalism in the first place. So I think neoliberalism is also having huge impact on what we conceive the role of federalism to be. Today, at least to some extent, we see federalism as a way to have competition between states to make it more business friendly. And I don't know if that's replicated in other states. It is in the US, for instance, with Delaware laws trying to be as liberal as they can to companies. So today, perhaps federalism and neoliberalism mean something very different from what it did 50, 60 years back.
That's a very interesting point, because when you were mentioning that this sort of race to the bottom between states in the same country, I was just thinking about, say, the contrast between labor laws in a state like West Bengal versus labor laws in a state like, I think, UP. With COVID, I'm not sure if I have the year right, but maybe in mid 2020, there was this sort of loosening, this weakening of labor laws in UP. And it was to sort of, certain states, I think UP started it, but to sort of attract more investment. So yeah, that's a very interesting point. Yash, would you sort of like to round out our discussion before we close for today? Close this session for today, not generally. Yeah.
Right. Thank you. In the reading by Professor Tillin on federalism, economy, and welfare, it's argued that perhaps federalism had its origins in a desire of Indian capital to have industrial development at an all India level, and in some sense unification of markets, etc. Just to point to the present, the repeal of the farm laws by the central government, which were enacted, based on powers otherwise mentioned in the concurrent list, which was the marketing of agricultural produce, and not directly entries which were otherwise in the state list, and the ensuing elections cycle which is coming in 2022, particularly Punjab and Uttar Pradesh, and this establishment of a dual polity in the Indian Constitution suggests to me the contrary, that the practice of Indian federalism and the constant cycle of elections, which this government has particularly expressed its reservations against, suggests that this establishment of a dual polity provides for a more staggered and perhaps a disunited market than what I think the author points in terms of origins of Indian federalism. So I think the practice suggests somewhat contrary results. Yeah.
We should have like a question and answer session with Professor Tillin, so you'll have the chance to directly pose this question to her. So we will just take a 5-minute break now. And now it's 3:21, so maybe we can all be back by 3:26.
Okay, I guess we can start with part 2. Thank you, Varsha. So in part 2, what I'm going to do is I'm going to take you through 2 cases just to see a judicial interpretation on how the powers can be used by the center and the state, specifically the necessary and proper clause that Malvika had told us about, as well as in India, the incidental and ancillary clause, as well as the pith and substance rule. So the first case is National Federation of Independent Business versus Sebelius, which is a 2012 case. As Malvika had previously stated, on a close analysis of the words of the necessary and proper clause, we know that there's a 3-point criteria for a federal law to be within the scope of necessary and proper clause. The first one is that it needs to be necessary, second, proper, and the third is that it needs to be in place for carrying into execution some other federal power. Now, historically, as she stated, most of the controversy around the meaning of necessary and proper clause was centered around the word necessary. And until quite recently, the word proper played no serious role in constitutional debates about the meaning of the clause. In NFIB versus Sebelius, there was a constitutional challenge to Obamacare, which was the federal healthcare law. And the court was divided over whether a law could ever fail to be proper if it didn't involve direct federal regulation of state governments or state officials. So what happens in this case is that there's a federal law, which is the Affordable Care Act, which is passed, which contains a minimum coverage provision by amending the tax code and providing an individual mandate which compels individuals who have failed to purchase and maintain a minimum level of health insurance to pay a tax penalty. So the ACA also had several other provisions, but we're going to focus on this particular individual mandate that actually makes it necessary for them to purchase a minimum level of health insurance. So shortly after this law was passed, 13 states in total brought actions against this particular law, and they argued that the individual mandate exceeded Congress's enumerated powers under the commercial clause. This is the main argument that we're going to talk about today. So what the commercial clause does is that it allows the Congress to regulate commerce with foreign nations, among several states and with the Indian tribes. So these are the 3 areas where the Congress can create laws. Now, what the court does is that it finds that the individual mandate does not target existing commercial activity, but rather it compels individuals to become involved in one. So the court held, based on other precedent, that the individual mandate is too broad in scope to be deemed proper to the aims of the Affordable Care Act, especially when there is no commerce clause to support the means by which a necessary and proper legislative power is exercised. So because this particular mandate does not really fall under the Commerce Clause itself, the doctrine of necessary and proper clause cannot be exercised in this particular case, is what the court then goes on to hold. The next case that we're going to look at is the Indian case, which is Host Pharmaceuticals Limited versus State of Bihar and others, which is a 1983 case. So in this particular case, under Section 5 of the Bihar Finance Act, dealers were prohibited to recover surcharge taxes from consumers. However, this was in contravention to the central government order under the Essentials Commodities Act. And the Essential Commodities Act order actually allowed the manufacturers to pass this particular tax burden to the consumers. So what happens is various dealers, including Host Pharmaceuticals, challenges the provisions of the Bihar Finance Act on the grounds of repugnancy, which is inconsistency with the central government order. Now, there are multiple arguments that are, of course, raised before the court. So the ones that we're going to focus on are the petitioners' arguments, where they contend that under Article 254, the laws enacted by the state legislature, which are repugnant to the law enacted by the parliament, are void to the extent of repugnancy, again, under Article 254. The respondents, on the other hand, contend that under 246(3), they had exclusive power to enact the law with respect to fields listed in List 2 of 7 schedule, which is a concurrent list, the state list. Further, they contended that the claim of consistency did not arise, as the claims relating to repugnancy under Article 254 would only arise in matters relating to concurrent list. Now, in this case, the court states that the Bihar Finance Act in pith and substance falls under entry 54 of list 2 of the 7th schedule. The encroachment of the law on entry 33 in list 3, which is the concurrent list, was held to be inconsequential, as the court held that the contention before it was not regarding consistency, rather about constitutional validity under pith and substance, which examined whether the substance of an act was in relation to the field of entry, thereby giving it competence to enact such law. So the court addresses the difference between legislative competence and repugnancy by clarifying that repugnancy provisions could only arise when both state and union had the requisite competence to enact laws on the same. However, if the state law would fail due to lack of legislative competence and not repugnancy, which it highlighted by emphasizing on the phrase subject to in Article 246(3). Now, with respect to incidental encroachment, the court noted that there was bound to be overlap between various fields mentioned in the 3 lists, and emphasized on the doctrine of pith and substance again to evaluate whether the enactment fell solely within the list claimed and its encroachment on the other list contended was simply incidental and ancillary. It was examined that the Bihar government had the requisite powers to enact such a legislation under list 2, which is the state list. And it also held that the 2 provisions in question operated in 2 separate and distinct fields, because of which there was no real clash between them. And so there was no real inconsistency. So what we do know from this case is that obviously the court delves deep into the idea of inconsistency. However, when it talks about pith and substance and incidental and ancillary encroachment of the state or the center into another list, it says that it's allowed as long as it is within the pith and substance of what they aim to do. Now I will quickly pose the activity question. Thank you, Asha. So I'm just going to read it out, and similar to the session that we had prior to this, we will divide the students into 2 groups. I'll first read the question, and then I can tell you what the activity, and then I can tell you what the question is. Health is a state subject in country X. The union legislature has the power to legislate on the following matters. First, imposing and collecting taxes, duties, imposts, and excises. 2, welfare of labor, including conditions of work, provident funds, employers' liability, workmen's compensation, invalidity, and old age pensions and maternity benefits. 3, legal, medical, and other professions. 4, provide for the common defense and general welfare of country X. The union legislature passes a law regulating hospitals in country X to prevent the spread of COVID-19. So section 2 of this particular law that they pass mandates all hospital staff to be vaccinated. Section 2 is challenged by state A in country X with the most number of hospitals and relatively low cases of COVID-19. State A claims that the law is ultra vires of legislative powers under the Constitution. So now when we break the students into 2 break rooms, we'd like break room 1A to adjudicate this matter as if they were the US Supreme Court, and break room 2 would have to adjudicate this matter as if they were the Indian Supreme Court. And what we want the students to do is use the necessary and proper clause, as well as pith and substance rule and incidental and ancillary, the doctrine of incidental and ancillary powers, to sort of come to a conclusion as to whether such a law, and specifically section 2, would be ultra vires of legislative powers under the Constitution. We will be putting the activity question in the chat box as well. And Varsha will start dividing all of you into 2 groups.
You may want to say to the students that people who presented on behalf of the group yesterday cannot present today or something of that sort.
Sure, we'll do that. We're just going to go into each breakout room to tell them when to come back. So we'll do that one later. Thank you.
Your throat seems to be worse today.
Yeah, I don't seem to be getting better.
Same thing's happening to me as well.
Yeah, I just recovered from COVID, so it's taking a while, I guess.
My last day of quarantine today.
Oh, great.
Is it 5 days or 7 days, Parna, the quarantine?
7.
Bangalore, okay. 7. Here. But by the 5th day, usually they become sort of.
So, I mean, most of my symptoms were gone by the 5th day, except this cold, bad cold. So no fever or anything, but this cold cough.
Even
discussion was, it was a good discussion.
So it's like I said, it's a mix of third years, fourth years, and fifth years, but they're also master's students. Half of them are master's students. So many of them, this is their third higher degree, because they'd have their undergraduate, many of them come from graduate 3-year programs of LLBs, and then they've come for their master's program. So
okay. So now at this point they would transition what to sit bar exams?
So the undergraduates will go for the bar exam. The master's students will already have, most of them would have done their bar exams and are preparing either for careers in academia or the judiciary mostly.
Mm-hmm. Yeah.
Okay, great. I think we have everyone back. So maybe we could start with, since we always start with breakout room number 1, we could start with breakout room number 2 this time around, and they could tell us how they adjudicated this matter if they were the Indian court.
Right. So in breakout room number 2, we had initially a discussion on the fact that whether the management of the COVID-19 pandemic is done under the regime of an extraordinary law like the Disaster Management Act, and where the governance in terms of norms and orders, etc., which different governments are supposed to follow, national and state, have been enunciated by the Disaster Management Authority, right? So if that is the case, then of course treating it as an extraordinary situation, perhaps without going into the question of the validity of Section 2 in terms of its legislative competence, the answer is that it is the mandate of the central government. But if that is not the case, there was one perspective which stated that regulation of hospitals, that is what the subject of the law is about, is largely, in substance, it lies with the legislation. Prima facie, it lies in the state list, which is health as a state subject. But then there were countering opinions to suggest that medical profession, right, which is to say professionals, etc., and labor clause, etc., which allows the center to legislate, because the legislation only provides for vaccination for hospital staff. It doesn't say vaccination for everyone in the state, right? Second, there was an argument that it deals with national security, defense, etc. So if we interpret COVID-19 as an act of bioterrorism, etc., and a threat to nation security, then again, it falls out of the mandate of the state list and reaches the center's domain. But again, if we do not do that as well, and look at the legislation only insofar as consideration of management of hospitals is concerned, I think it rests with the state. And to that extent, the legislation is ultra vires the constitution. And then we were towards the end having a discussion on the doctrine of severability, whether some sections could survive and others could not. But again, that is still I mean, that's something which is still open. But yes, these were the broad arguments.
Great. Thank you, Yash. I just had one more question though. So there's also one provision which allows the center to infringe on, intrude on state powers when it comes to general welfare of the country. Maybe we can put this up as a question for later, but maybe that's something to think about, whether it could just be the center's intrusion to ensure that there's general welfare of the country. And so would that still then would that still mean that this particular law is actually unconstitutional?
Right. I think Satyajit brought this point during our discussion. Sorry.
No, don't worry.
Satyajit did bring up this point during our discussion and mentioned that if it's about welfare and it's a pandemic level situation where the virus does cross state borders, then of course the matter reaches the jurisdiction of the union government.
Great. Would breakout room number 1 like to put forth their arguments, and then we could quickly open up?
I'll go ahead for breakout room 1. So the brief, it's basically twofold. So the law is essentially saying that Congress has the power to make all laws which shall be necessary and proper for carrying the foregoing powers and all the powers that has been vested into the government of United States. So the first question is whether the power itself to basically for which the act has been enacted in the first place falls within the union power or not. And I think the answer is yes, because there are at least 3 different heads under which it can be covered. Number 1, the welfare of labor, including the condition of work, because we are talking about the medical staff, which is working and taking care or treating the people who have already been affected by COVID. So that is number 1. Number 2, legal, medical, and other professions, because again, we are talking about hospitals. And lastly, general welfare of the public, right? Because you need the doctors to be safe, right? And the hospital staff to be safe. If the general public could be treated to begin with, right? Because doctors are the one who are treating them. So the answer to the first question is yes, that it, the power to basically and make an attempt to prevent the spread of COVID-19 is definitely within the powers of the union government. Now, coming to the second question is whether it is necessary and proper to execute its union powers. Will it be encroaching upon the state subject, that is the health? Yes, but I think it is incidental as well as necessary, because considering you already have powers to govern the medical profession and general welfare and the conditions of labor, it is absolutely not possible to execute its power without having some sort of control over the hospitals, right? Even if the broad category of health comes under that state subject. And I think it also depends to an extent on the interpretation of health as well as the medical profession and the general welfare, right? I mean, at one point you're talking about by health, what exactly do you mean by that? Do you mean that the providing of medical services to the common people? Are we talking about that? Then maybe we can say that there's not even any encroachment to begin with, right? But if you just interpret the term health in a bit broader way, then you can say that, okay, there is encroachment, but in any case, we just believe that, okay, it's necessary for executing its the powers which have been vested with the government of the United States.
Understood. Thank you, Priyanshu. So what's interesting is here is that although we have doctrines that have that sort of have a similar purpose, we come to 2 different conclusions. So the question I sort of want to pose to all of you is, do you see some sort of, is there glaring difference in the necessary and proper clause as well as the bit and substance / incidental and ancillary clause that we follow in India? Or do you think they serve similar purposes? And is that the reason that we probably came to 2 different conclusions in this particular activity? And this is open to everybody, so there's no, whoever wants to answer can answer.
I don't have a lot of idea about the necessary and proper clause doctrine, but I think the Indian counterpart is broader in terms of its scope. That means I think it leaves more leeway to the central government or the state government for that matter to like encroach upon the past, because here the term which has been used is necessary. I don't have like any particular idea as to what has been the interpretation by the US courts in necessary, but yeah, I believe like in India it's more relaxed as compared to the US court.
Would someone from break room 2 want to take this? Because since Priyanshu thinks it's broader, that means ideally there wouldn't have been an infringement of the state law. So would somebody like to counter with what you guys thought and why you thought it wouldn't be it would be an infringement?
I think Vrishank has his hand raised.
So I think while I mean broadly I agree with Priyanshu in that it is slightly broader without doubt, because in necessary and proper you have to prove that it's necessary and proper for an enumerated right. But it's not as if it's so broad, because in India it's not like we say that the state has enumerated rights and everything else is the center. If that was the case, then it's perhaps a lot broader and along the lines of what Priyanshu is hinting at. But as we read in the article that you gave us, India didn't want to choose between sort of I think the Australian or the Canadian and the US version of it, and they went with enumerated powers for everyone. So I think because of the fact that there are enumerated powers for everyone, the residuary clause is something that comes far towards the end. The first question that you still have to figure out, and you have to do a lot of analysis on, is which enumerated power does it come within. And I think because of the reason that we have to end up doing that analysis first, which is that there are 3 lists of enumerated powers, where does it fit in? The residuary clause perhaps isn't as broad as we would otherwise think it is, because it kicks in at a far later stage. So that's the only qualification that I'd add. And yeah, just to sort of more pointed answer to you, the reason we thought it's an infringement potentially, at least some of the arguments are raised, is because even though there exists the residuary clause, there was an enumerated clause that the state had, which was held, which it could come against. So like I said, first you do the enumerated analysis and then the residuary analysis. So yeah.
Actually, if you look at the practice of the Supreme Court in how it uses the residuary clause, it may not bear out what you're saying, Vrishank. The court comes to the residuary clause actually very quickly. So unless you can show that there is an enumerated power in the state list, for the center, the court doesn't really get into the question of whether it falls within one of the 2 lists, concurrent or the union. It very often quickly goes to the residuary clause to say that in any case there is the residuary clause. So unless you can show that something is specifically enumerated in the state list, it can move quickly to the residuary clause or to the concurrent list if there's a question of repugnancy. It moves very quickly to the residuary clause. So you would think that the fact that there are 3 enumerated lists means that the residuary clause is an exception right at the end. But if you look at least the jurisprudence of the court, that doesn't really, that's not the approach that the court has taken. And a larger question to then think about is also how the Supreme Court's own approach to this question has furthered the centralization of the centralizing tendencies of Indian federalism. Yeah. I also, sorry, just as a second point, I just want to link this to some discussions we've had in class on comparative methods, is to also say, to get to the point that Priyanshu was making of the difficulty in trying to understand the necessary and proper clause. It's not just about the doctrine that the court has developed, but also the ethos of the court, right? The culture, the constitutional culture, the kind of arguments that make sense in a particular given context and the kind of arguments that don't make sense. And we have some kind of an intuitive sense of the arguments that will make sense within our legal culture, the culture that we are familiar with. But we don't necessarily know what kind of arguments, unless we are well versed with American constitutional law, we might not have a sense of what are the kind of arguments that will fly in the American setting, and that's the legal culture, constitutional culture question that we've looked at in some of our previous discussions. So if you actually look at American constitutional law on federalism questions, the issue of state rights and the issue of state power is front and center. And your starting assumption very often is, for the court, is that it is the state's preserve unless the central government can make a very good case of it, right? So the burden is always on the central government, and that comes from both, of course, the constitutional division of powers of the federal structure, but also a long history of political battles and actually physical battles on the question of the federal division of powers in the US. And that's not the court culture, the legal culture, when it comes to arguments around the federal division of powers in Indian courts. So just again highlighting the role of intangible things like constitutional culture and legal culture in shaping what kind of justifications are considered to be valid and what reasoning are considered to be valid in the different courts.
Absolutely. And I think that I found that point really interesting, because if you go back to the reading on the different stages, different phases of the US courts and their interpretation of federalism, I think there was something on the Rehnquist court and then the Roberts court. So you can see that even in a single country or even in 100-year span, there has been this sort of evolution of doctrine. And it's interesting to see how we can contextualize it. Of course, when we go back to the founding and we talk about how yesterday we were talking about slavery in the room and the kind of thrust of the southern states to not want to give up their powers as give up their the practice of slavery. You sort of see this evolution in that sense, and it's difficult to sort of comment on provisions of a constitution without understanding the overall evolution and the phases that it's gone through. So maybe a Roberts Court would, perhaps decide very differently from, say, a Ginsburg Court, if there had been one. So yeah, so I think now we can move on to our speaker, and Kalyani can introduce Professor Louise Tillin.
Thank you, Malvika. So today's speaker is Professor Louise Tillin, and she is the director of King's India Institute and a professor of politics. She joined King's and the then newly established King's India Institute in 2011. Professor Louise's research interests span federalism, democracy, and territorial politics in India, and the history and politics of social policy design and implementation. Since 2011, Professor has led research projects on subnational comparative politics and social policy in India, on expanding electoral change in urban and rural India, and on India's political economy. Between 2013 and 2017, she was a part of multi-country research program on the politics of reducing poverty and inequality across Brazil, China, India, and South Africa, supported by the ESRC. Professor Louise is a regular commentator on Indian politics in UK, Indian, and international media. She is an editor of the journal Regional and Federal Studies and an editorial board member of Pacific Affairs. She has also authored several books, including Remapping India, New States and Their Political Origins, and Politics of Welfare Comparisons Across Indian States. Professor, over to you.
Thank you very much for that introduction, and also for inviting me along today. I have to say I've already learned an awful lot from listening to the discussions, and it gives me, lots of hope to see the next generation of constitutional lawyers engaging so seriously with these questions of federalism, which are so crucial today. I don't have a prepared talk here. I thought what I would do was really to pick out some of the points of conversation that you've been having so far and offer a few reflections. And I might also touch on the reading that you've that was assigned, one of my short readings that was assigned as well. But I think I'd like to also leave some time for discussion with you too. I think, you know, the point I wanted to start with was one around dynamism and flexibility when we're thinking about the interpretation of the division of legislative powers. And the contrast between American and Indian federalism is quite telling here, if you like. One of the reasons why Indian federalism is so distinctive is because its historical origins are so different from the earlier models of federalism adopted elsewhere. The US, of course, being the paradigmatic case of that first wave of federalism, if you like, historically. And the socioeconomic and political circumstances that the Indian Constituent Assembly faced in framing the Constitution were vastly different to those of the American founders. And so, you know, in my recent work, I've tried to suggest that not only were the Indian founders grappling with how to build a nation in a moment of post-colonial transition, but that they were also grappling with how do you respond to the demands and impetus towards the construction of welfare states in the mid-20th century, and with the challenge of bringing together a national economy. And they were doing that in the circumstance of the integration, not only of the formerly British Indian provinces, but the task of integrating princely states. And that challenge had also sat behind the earlier colonial exercises in framing the Government of India Act. Of course, the 1935 imagining of what a federal constitution might look like for India never actually really came into being. But if it had, it would have involved a federal chamber of sorts that would have provided representation to both princely states and to British Indian provinces. And it's that task which also remained for the Constituent Assembly to grapple with as well. So when we think about the kind of holding together dynamics, to use Alfred Stepan's frame, that holding together in 1950, I think was in important ways as much about the diversity of the history of governance in different parts of India and integrating political units with very different histories, both of, the experience of holding elections, so very different, trajectories of democratization, but also different histories of rule and relationship with a central authority. And it's only over time then that the kind of design of Indian federalism changes in ways that are more deeply associated with recognizing the forms of diversity, especially linguistic diversity, but also the other forms of ethnic diversity that you've touched on a bit today in terms of the 5th and 6th schedules, and which I think are why today India would be described as a holding together federal system. But I think we need to kind of keep in mind that the forms of diversity that shaped the Indian Constitution of its founding and its structure of federalism were, not only concerned with ethnic diversity, but also with that diversity of kind of history of governance arrangements. The other important part, I think, of what makes Indian federalism distinctive is its centralism. And that's, of course, what you've been grappling with here. And the contrast with the United States is very instructive in showing how a different pattern of federal origins can produce a different type of federal constitution. And sorry, I'm meandering here, but that point comes back to thinking about dynamism. So India deliberately designed a distinctive model of federalism that was more centralized and did so for a very clear set of reasons in the mid-20th century. And it took on board contextual issues that were not on the mind of the architects of the American Articles of Confederation or of the American Constitution. India today, as every federal system and unitary system, needs to grapple with new policy problems that weren't necessarily on the agenda at the time a constitution was defined. So of course, all of that makes the job of constitutional lawyers absolutely critical in interpreting where dynamism is appropriate in thinking about where the burden of legislative authority lies and where it starts to trouble a constitutional order so much that it starts to break down the kind of the principles of federalism that underpin it. So you all have an important task on your hands, I think, in interpreting the bounds of that dynamism. The other provocation I wanted to offer here, and just chatting to Aparna while you were out in breakout rooms, I think this might be something you've also talked about in class, is that I increasingly wonder whether it's useful to describe Indian federalism as quasi-federal. And a number of you use that term in the discussions today. It's a very easy shorthand, I think, but I wonder if it is increasingly a bit of a lazy shorthand, because quasi-federal comes, of course, from the work of Kenneth Weir, who was writing in, again, the mid-20th century, just as Indian federalism was coming into being. And the reference is, by contrast to the older classic American form of federalism. But now that, we have the kind of perspective of 75 years of the functioning of Indian federalism, whether it is actually incumbent on us to start to define what is paradigmatic about Indian federalism. So rather than seeing it as a diminished form of federalism that was established somewhere else, whether actually it is possible to say, we actually should see Indian federalism as being a distinct model of federalism, not a kind of shadow of something that operates more fully in the United States, but actually a form of federalism that was designed with reference to the particular set of challenges and in the particular historical context that in which Indian federalism was designed. That doesn't mean it operates, we might have all sorts of critiques that we might make of federal practice. But I think, it is important, I think, to question our usage of quasi-federal, partly because, for those of us who think that upholding the culture and idea and spirit of federalism is important at the moment, I think being able to confidently define what federalism is and what its purposes might be is important in and of itself. And I think too often quasi-federal is used to kind of suggest, well, we aren't really, this isn't really federalism. So why are we even describing it as such? So, I'd like to kind of push you or hear your thoughts really on how useful you really think that quasi-federal term is. And I might just kind of conclude then in a point that slightly relates to that, which is lots of the discussion here, and I think often when we think about the way that the kind of constitution influences the practice of federalism, there's a kind of natural recourse back to thinking about what was the original intent. And of course, this is, happens in the US debates a lot as well. What was the original, intent behind the framing of the constitution, and should that be, should that inform the way we interpret the workings of federalism today? There's a lot of kind of criticism in America of that way of thinking. It often tends to be deeply conservative. It doesn't leave space for thinking about how the respective roles of levels of government may need to change in order to, respond to collective action challenges, to, empower federal intervention in areas that have become important in ways that the founding fathers couldn't have imagined, and vice versa in the Indian case, to enable the autonomy of states to define policy solutions, for instance, that are responsive to local needs or local preferences. So I think we shouldn't overemphasize the question of original intent, and we should also recognize that federalism is not only about a constitutional text, it's about an idea and a culture, and of course it's also about the structure of political power. So the form that federalism takes over time shifts, and we of course are in a phase at the moment of acute centralization, and a form of centralization that in some ways is enabled by the kind of the proclivities of the constitution towards the empowerment of the central government. But that is not necessarily a one-way street, and I think we need to move often beyond the constitution to define and bring to life a debate about what federalism is beyond quasi-federalism, and what it means to talk about federalism as an idea or culture that might permeate political practice. So kind of a slightly mixed bag there of thoughts, but really inspired by the kind of ideas that I've heard you kicking around here today, which have been really interesting to eavesdrop on.
Thank you, Professor Tillin, for that extremely interesting and thought-provoking talk. I was especially intrigued by your provocation as to whether we should think of federalism beyond quasi-federalism. And I feel like we have been using it as a sort of lazy shorthand, and maybe it's time for us to interrogate and to understand why we use that term and whether we've evolved not just constitutionally and judicially, not just in terms of doctrine, but in terms of culture, to a different and unique form of federalism. So open the floor for questions.
Feel free to raise your hands and then we can start with questions.
Pranav?
Hi, Professor Tillin. It is great to speak with you. One part of the Indian federalist provisions is that the Supreme Court plays a central role in deciding federal disputes. But if we look at, and this is just my reading of it, if you look at the recent practice of Supreme Court, and even like for at least last 15-20 years, the court has played a role in not deciding some disputes. And if it's deciding some disputes, it's sometimes in a way that centralizes power and gives certain issues which were to be subjects of state decision making to the central decision making. One example of that is the debate around medical education and NEET, which we see various states like Tamil Nadu up in arms. So how do you view this role of the Supreme Court, and does that also inform like a special characteristic of Indian federalism, wherein the Supreme Court plays a centralizing role in constitutional interpretation?
Should we take a few questions, Malavika? Just conscious of time, I could maybe respond to them.
That's perfect. Satyajit, do you want to pose your question as well?
Yeah. So mine is a slightly elementary question, but I was just wondering if Professor Tillin, you could tell us how our changing idea and definition of federalism, and when we talk about a uniquely Indian characteristic, how that impacts the practice of federalism today. Because my understanding would be that more often than not, it comes down to assertions of political power. So if we, let's say, compare practicing federalism today vis-a-vis, let's say, what it was in the coalition era in the 90s, and there's probably a vast difference in how we would imagine federalism. So I was just wondering if you could tell us exactly when we talk about specifically Indian federalism, how that impacts us in day-to-day practice.
Vrishank?
Hi, Professor Tillin. So just a question on something we were discussing earlier. So your thesis is, from what I understand from the extract, which is that India was trying to create this sort of a national welfare state, and that's why there's this sort of federalism that we have. But going back to the point that I was making earlier, which is we also have to look at it as states themselves as having power and themselves as negotiating players. And I'm wondering what exactly happened in the Indian context, because I'm sure the states themselves were trying to assert some power of their own. These were, at the end of the day, princely states that had a fair degree of autonomy, even during the colonial era. So were there attempts for them to say, no, we need more power, or were they also willing to give up this power and say that there should be some sort of centralizing tendency? Because as a princely state, if I'm getting inspired by the US Constitution, I'm thinking perhaps I should also be having the sort of powers that they do. Why should I be giving away so many powers? So just curious to know what the negotiations were like as well there.
Maybe we can take Shantnu's as well, and then Professor could answer those questions together.
Good afternoon, Professor. There is a book of yours, that's Indian Federalism, where I remember that you argue that India has become more genuinely federal as a result of the political and economic change. How do you look at this assertion in view of the current changes by events like GST and others, which has brought fiscal federalism into due to the changing natures, particularly in terms of the financial arrangement between the center and the states?
Thanks to all of you. Shall I take those questions now? I can't see any other hands. Really good questions there. I think let me start with Vrishank on the negotiating power of states in the Constituent Assembly. What I found, the reason why I started tracing the origins of the why labour laws were placed in a concurrent list was a debate that was raging among mostly in British Indian provinces after the introduction of the Government of India Act, where those that were more industrialized, so Bombay Presidency was at the center of this, but not only, were starting to introduce forms of social insurance that placed costs or had the potential to place costs on industry in those provinces. So Bombay, for instance, had introduced maternity benefits, and it was discussing the potential to introduce sickness insurance, so paid sickness leave and health benefits for industrial workers. And it was doing that partly in response to the pressure of industrial unrest in Bombay. Similar discussions were happening in the central provinces as well, and in other places with kind of large concentrations of cotton textile industry. But these older centres of the cotton textiles industry faced competition from newer entrants with lower labour costs and no regulation of labour. So it was actually from places like Bombay that you started to see the calls for greater centralisation. So it was, in Bombay that industrialists, and in central provinces, where industrialists were saying, we need national labour policy in order for us to be able to bear these costs. Otherwise, if these costs are only placed on industrialists in Bombay, then we lose out because of competition in other places with kind of newer entrants to cotton textiles, which included princely states as well. So some of these debates, some of these demands for centralisation were very much coming from the states, not all states. There are also, interesting kind of discussions in various commissions on, labour standards. And I remember one from Kanpur, for instance, where factory owners in Kanpur were absolutely viscerally opposed to any kind of labour regulation. And you have Congress leaders then trying to reason with them to say, we are nationalists here, and we have to bear some additional cost, the kind of additional costs here in order to hold together this project that we're all engaged in. So there was really interesting interplay happening between different, not all of these became states, but between different provincial interests about the balance of central power. But this is a really fertile territory for more research. So if you're interested in this question, I encourage you really to go and explore it further. I've only looked at one slice of this debate, really. So I'm not suggesting that all centralization, that the welfare impulse was, responsible for all of the centralism that we see in the Constitution. But what I'm saying is this is an important strand, I think, of centralizing thinking, especially in Ambedkar's mind. Because Ambedkar, and this is very often forgotten, but Ambedkar was the Minister for Labour on the Viceroy's Executive Council in the war. And Ambedkar was responsible for framing a lot of the labour legislation that came in just after the war and just after independence, on things like sickness insurance, for security provision for the formal sector Ambedkar was heavily involved in. And, he's not going to see, we can't separate that obviously from then his thinking about the Constitution and the role of the central government in social and economic policy. So, so I hope that gives you a bit more of a sense of where my thinking on that comes from. Pranav, on the Supreme Court, I slightly defer to all of you actually to inform me better about the role of the Supreme Court. But I think this is it's a really, really important question. And, I would like to see a decent analysis of how Supreme Court interventions or interpretation of distribution of legislative powers have changed over time. And it would be interesting to see how that tracks political change as well, relating to Shantanu's question about, how 10 years, well, not quite 10 years, but almost since the election of Modi. I take kind of Sajid and Shantanu's question together. I need to wrap up then. But how would the era of federalism help to change the day-to-day politics of federalism? I mean, of course, we don't know, but I think you're absolutely right, Satyajit, that much of what we've taken to be an expression of a deepening federal culture in the era of political regionalisation was actually just an outcome of the pattern of electoral politics in that period. So we didn't, it wasn't that there was a very clear expression under the UPA of an idea of federalism. So, in a sense, it shouldn't be very surprising that today also what we see are assertions and counter assertions of political power between parties at different levels of the federal system. I think what I'm kind of pushing you all to think about is whether by moving beyond simply relying on the idea of quasi-federalism and seeing Indian federalism as somehow a diminished model of something else, if one can start is distinctive about Indian federalism, that itself may then percolate into the wider political debate. But I'll leave that to all of you to actually achieve.
Thank you, Professor. Thank you. I think that's a great place and a great provocation to end this session with. Professor Chanda, do you have anything to add before we close?
again, just coming at it from the point of view of court dicta, you see a lot of these Supreme Court cases, particularly in the 60s and 70s, that are grappling with the question of whether we are a federal country or not, whether we are, and they use these terms, right? Casey Weir is called as quasi-federal. Are we quasi-federal? Are we federal? Are we not? And they say we are not federal because we are not like the US. And because we are not like the US, therefore centralization is justified, right? So by not naming it as its own type of federalism, the court sees this as justification. If you look at all these state of West Bengal judgments, in the 1960s, 70s that are coming in, and remember the context is also Indira Gandhi also trying to assert, federal power over state units. And in that context, the court, at least, its imagination is caught by the fact that we are not federal because we're not like the US. So therefore, questions of state rights, or I'm using state rights very loosely, but the question of the power of states is subordinate to the national imagination. But if you think of the Indian federal order as its own kind of federal order, then you have to ask the question of what actually is the division of power between center and state, and not just have this kind of lazy assumption that it is actually only centralizing, right? So there is, I think, we have definitely paid the price of thinking of the Indian Constitution as quasi-federal, at least when it comes to the judicial imagination. Second, just to on Pranav's question about the courts, Supreme Court's role, in the US, because we're doing this comparison with the US, there's actually literature that the US Supreme Court has played a very important role in the centralizing tendencies within US constitutional law. And the reasons that have been, at least there are many scholars that have said that there are two reasons for this. One is that the court itself, the judges of the US Supreme Court have a national imagination. They're dealing with problems from across the country, and so therefore they imagine themselves as sort of speaking to a national constituency. And that for the US is, of course, that they don't have a unitary judicial system, right? The US Supreme Court becomes more powerful if more matters are part of the federal jurisdiction. Because if a matter is within the state jurisdiction, then the state Supreme Court is the final authority on virtually all questions. There's only a limited set of circumstances where the matter can go to the US Supreme Court. So for very many self-serving reasons, the US Supreme Court has played that role definitely in moving towards a more centralizing tendency in the US Constitution. That, of course, is not true for the Indian Constitution because we have a unitary judiciary. So just to place that contrast with the US courts, and to say that, of course, we'll have to evaluate the Indian court's jurisprudence on its own terms to see whether and what role it has played in the centralizing imagination of Indian federalism. But thank you so much, Professor Tillin, for those remarks and for engaging with us. That was truly fantastic, and we hope next time you're able to travel to Bangalore in person, you'll pay NLS a visit and hope to organize some talks by you here as well.
Absolutely, I'd really enjoy that. And I hope it will be possible to visit Bangalore before too long. So, thank you for the invitation today.
Thank you, Professor Tillin. Thank you, Professor Chandra. I'd also like to thank Ms. Usha Davalur from the US Consulate Chennai, who supported us in making this happen. And we'd have, of course, loved to do this in person, but something that we would have done if you were in person was take a picture. So it'd be great if you guys could turn your videos on for just a minute so we could probably get a picture. Great, I've taken a couple. Thank you so much. We will meet again tomorrow for the interactive session between NLSIU students as well as students from Tulane Law School. Thank you, have a nice evening.